My name is Frederick Nyberg. I'm the Managing Director for MedTech Innovator Asia Pacific. A warm welcome to this third webinar in our series. Today's discussion is going to be around market access and expanding borders, legal strategies for establishing entities overseas, and entering overseas markets. So as many of you on this webinar will remember, we conducted a survey at the beginning of the Accelerator program and asked all of you to submit questions. And we then compiled those questions and they helped us shape the topics for this year's webinar series. So this was one of the topics that came up. We've not done a session on this before, so I'm really excited about presenting our panelists here in just a moment and get started on this. So Bernice, if you want to begin the live stream, you're welcome to do so. So again, warm welcome everyone. Today's topic is really about establishing legal entities overseas, about developing legal strategies specifically for overseas market entry. We have a great panel here. We're honored to have Alison Wong here, partner at Bird & Bird, dialing in from Hong Kong. We have Catherine Wang here, partner at Ropes & Gray, normally based in Singapore, I think dialing in from Taiwan today. And we have Justina Zhang here from Herbert Smith Freehills, dialing in from Beijing. So we have a really interesting set of skills and expertise amongst our panelists, both in terms of deep healthcare and medtech expertise, as well as corporate legal background. So without any further delays, let me turn to our panelists and ask you each to just briefly introduce yourselves, tell us a little bit about your firm, and some of your key areas of focus. And maybe let me begin with Alison. You're on mute, Alison.
Sorry about that. So my name is Alison Wong, and I'm an IP partner in Bird & Bird, based in Hong Kong, covering China, Hong Kong, APAC. I head up the life sciences and healthcare practice. I've been a practitioner for over 25 years, and I assist a number of life sciences and healthcare companies, in particular big pharma, multinational MNC, medical device companies, and also startups as well, and universities, clinics, etc. Bird & Bird is very well known for IP and regulatory, and we focus on key sectors. So life sciences is one of our key sectors, tech and comms, media, entertainment, etc. And what we've seen in the last, I would say, 5-6 years is like a double-digit growth in our business in terms of servicing life sciences and healthcare clients. So it means that, you know, the industry is very buoyant, and we are seeing really good startups coming through, and we help on the corporate side. I'm not a corporate lawyer, but in terms of funding, fundraising, and in particular, we see Hong Kong as being a very, very buoyant jurisdiction for startups.
Excellent. Thank you for that, Alison. And next, let me turn to Catherine at Ropes & Gray. Welcome.
Hi, everyone. My name is Catherine Wang. I'm a partner at Ropes & Gray in the Singapore office. So Ropes & Gray is a global law firm specialized particularly in life sciences and healthcare areas. And my personal area of focus has been on the regulatory side of the pharmaceutical, medical device, and healthcare business players. So essentially, I work with a lot of multinational pharma and device companies on their operational questions in Asia Pacific, with a particular geographic focus on Greater China, and also help the companies navigate the regulatory landscape in terms of getting the products approved and trying to comply with post-approval requirements, and also address market access requirements. Our firm actually work mostly with companies in cross-border transactions, particularly with respect to in-licensing and out-licensing of the core technologies. And also there are more and more divestiture from multinational pharma companies in China in particular. There are also a number of formation of new companies using it as a platform to license in assets from Chinese biotech companies for globalization. There's also interest in exploring product level acquisition or even company level entity M&A opportunities. So it's a great honor to be invited by MedTech Innovator today to sit on the panel. I would love to learn from my panelists and also answer questions from the audience.
Thank you so much for that, Catherine. And finally, let me turn to Justina at Herbert Smith Freehills. Tell us a little bit about what you do. You don't have that same background in healthcare, but you have done a lot of work in with companies in AI and software and digital in the digital arena, as far as I understand.
Cedric, thank you. Thank you for the brief introduction before I do. Hey everyone, I'm Justina Zhang. I'm a TMT partner at Herbert Smith Freehills, sitting at its COVID Joint Operation Office. My background is kind of more on the corporate side. I have been advising tech startup for their global structuring. And as I shared with Glenn yesterday, that today lots of startup is talking about build up a global company from day one instead of restructuring to a global company before it is too late. So my expertise is to do this kind of global structuring and to make sure that such structure supports the fundraising of a startup. In the meantime, I also help company do regulatory compliance and cross-border transactions. AI and data compliance has been part of my practice, and it will enable me to have lots of tech company in these fields to doing business in US, Singapore, and Europe. For the firm, tech has been a top priority. As a practice group, we have an emerging tech group. So basically, some brief introduction as other panelists have introduced. Yes, the Herbert Smith Freehills is a global law firm, and we recently merged with Kramer. So we have a 26 office global-wise, able to support startup that's expanding to major jurisdictions. I'm very happy to join today's discussion, and hopefully everyone enjoy our discussion, and we can share some insights with you that can help you set up your global structure as well.
Great. Thank you so much for that, Justina. And just as a reminder to our cohort companies, you are welcome to queue up your questions using the Q&A function at the bottom of your screen, and we'll get to Q&A in the last 30 minutes at 11 a.m. Singapore time. So let's begin, and because I don't believe any of our founders and CEOs here on the call have a legal background necessarily, so we can keep this relatively high level. What would be some of the first legal considerations that a startup should think about before entering a new market and before venturing overseas? Very high level question. Love to have some of the regulatory and IP perspective specifically from MedTech, but also Justina, you mentioned building a company that's ready to go global from day one. Be interesting to have your views on that as well. But maybe let me turn to perhaps Alison first and get your thoughts on that in terms of initial legal considerations for a startup going outside of their home market.
Okay, thank you. I think that for me as an IP lawyer, one of the key issues is considering the IP landscape, right? So in terms of really looking at where you can get registrations for your core IP and whether once you have those registrations, you can enforce those IP. That's one of the key issues, because in terms of exploitation or licensing or making product, this will be one of the cornerstones. Another issue is that what we always advise clients on is the regulatory environment. It is the case when medical devices are a highly regulated industry, and therefore it's necessary to identify what's the landscape in terms of being able to get regulatory approvals and how difficult it's going to be. Interestingly, in terms of looking across APAC, Hong Kong is one of the very, very few jurisdictions where medical devices and registration is on a voluntary basis. The reality is that many med tech companies, and in particular the big ones, will file registration because you really can't participate in tendering if you don't have the registration. But that regulatory, as Catherine knows, it's one of the big headaches in terms of what startup companies and also medium-sized bigger companies have to consider, because also in relation to APAC, all the regulatory approvals are different. And so whilst looking at a sort of geographical area and the market size, the amount of money that one has to probably spend on the regulatory aspects is quite phenomenal. Another legal issue to consider would be employment issues, employment law, because if the founders or the senior management or R&Ds or the key employees that you want to have within the business, but they want to go to different countries, it's very necessary to know how flexible or how easily these senior execs or people that you want to employ from overseas, because that could be an issue as to whether you do want to set up in certain countries. Hong Kong is quite a good jurisdiction because we are encouraging more overseas talent to come and do R&D here. I know that in other countries it's not so easy to have the fluidity of the movement of senior execs and R&D, etc. And then lastly, things like data protection laws, that's quite critical to see what you need to do to comply in the relevant jurisdictions, because there's a lot of data that you may be using for your development of your medical devices, etc.
Very helpful, Alison. Thank you for that. Catherine, your perspective on this, anything you might want to add in terms of legal priorities for companies venturing overseas?
Yeah, I would probably also supplement what Alison has mentioned, but from a different angle. I think actually in today's industry, it's very important to decide whether you want to build up your own brick and mortar presence in a market, or you just want to make your products available and technology available in that market. Because if it's the former, then usually we will consider a lot of implications about setting up corporate entities, the tax implications, and whether you want to actually manufacture the products locally. Especially for medical devices, if you have a manufacturing facility that has a lot of compliance requirements and expectations. But if you just want to sell products and make your technology and products available in one market, there are many different ways to achieve that goal. You can either appoint a distributor in that market without setting up any legal entities. You can also license your technology and IP to a company operating in that target market. So that company will become your licensee, potentially hold regulatory approval and pay you royalties and different milestones. So you just take commercial upside without necessarily have to worry too much about local law compliance. But essentially, you will also need to structure a supply chain, especially in today's environment, with I would say increasing pressure on tariffs. That could also potentially be an important priority to consider. You can also actually, just by thinking of ways to do R&D in many different countries, but consolidate your IP in one place. But by doing that, you also establish some form of a presence, primarily through your early stage research and clinical development agreements. So I think when we talk about entering into a market, to sum up, it's very important to understand what your business strategy is for the time being. There are also different considerations in different stages of a company life cycle, right? You can probably just focus on fundraising for now, so you can have a wide base of potential investors, but you would essentially just operate from a home market. So that's my perspectives.
Yeah, no, that's great, very helpful, and I appreciate this is a high level introductory question, and we'll go deeper on some of these topics in a moment. Excuse me, Justina, your perspective from a corporate lawyer side, and also some of the aspects that are more unique, perhaps to the tech sector, and you mentioned this designing a company to go global from day one. Tell us a little bit more about that.
Yes, thank you. I think Alison and Catherine basically share with you guys all the elements from legal perspective, that how you evaluate whether you are going to set up structure or entering certain jurisdiction for market. So from corporate side, when I design global structure for companies, when I talk with the founders, I would check with them first where you want to have your fundraising. Are you set up Cayman structure, Delaware structure, Singapore structure, Hong Kong structure, or in Europe you set up structure to enable to get investing? So that's the basic question: where you have the holding company, and which group or investor you would like to attract. And the second one is more like where the money is, including the marketing and access to investor from overseas. So my observation is generally lots of tech companies choose to set up US subsidiary and Singapore subsidiary was in both those two jurisdictions that you can easily access to investors you like. Not very familiar with European markets, but definitely they are favorable jurisdiction where you set up your holding company and a subsidiary. And of course, regulatory compliance, tax, and employment data and everything you need to consider. You definitely don't want to enter into certain jurisdiction that from day one, that once you set up the structure, you already breached the local regulations. Some regulations that you can fix the issue later, but for issues like tax filing, in certain jurisdiction, you can never fix it. Once you made a mistake, and you just need to figure out how you back up your plan, and probably that problem can never be fixed. That's my experience, quite different from Alison and Catherine, but I think you share common grounds as to compliance, as to how you enter into certain markets and what's the key risk you are going to face.
That's very helpful, Justina. Thanks for that. So you're saying fundraising should be a key driver in that initial maybe selection of what your priority jurisdiction should be in terms of expanding.
Yes, that's I think that's a very practical choice as to if you don't have money and you start up, probably unable to run for a long journey till you get IPO, being acquired by a third party. So unless your product's able to create the cash flow that you need to support your business, what I share with the founders is like, it's always great to have an investor invest in your startup, and so that you're able to expand your business as quick as possible.
Yeah, no, that makes sense. So as our core companies that are on the webinar today, the vast majority of them were over in California at our kickoff meeting last month, where we specifically spoke about legal aspects of entering the US market and the benefits of doing so. And it was a similar conversation. We had a law firm talking about if you're raising capital out of North America, out of the US, then it does make sense to set up that legal entity initially in the US. So on this webinar, we'll focus more on Asia Pacific, given that we've sort of essentially covered covered the US a month ago. Catherine, I wanted to turn to you again on regulatory strategy and pick up on a few of the things that you spoke about. In terms of whether a startup is working with distributors or a startup is looking to set up its own local presence, there are always challenges, anecdotal stories that we hear about problems with a distributor holding a product license.
Yes.
And when you then want to change your distributor or your distribution partner, they effectively can hold you hostage, or ask you to pay a massive amount of money to return that license to you. Any experience you have in that area, and what could a startup do to avoid that? I know we have in China, it needs to be held by a local distributor. In Japan, obviously, you've got the marketing authorization holder structure. What are some of your thoughts on this?
Yeah, actually, this is a very good question. This is indeed a challenge for many of the med tech companies, especially if they do not want to start with a very capital intensive model. They wanted to do capital light and leverage the distributor network in the country to sell their products. Indeed, in many countries in Asia Pacific, the regulatory approval is held by the local entity. Usually it's a distributor with a necessary medical device distribution license. But surprisingly, actually, China is a different case. China actually allows the marketing authorization holder to be the foreign legal manufacturer. But because there is also a role as the local responsible party or registration agent, that is like the local legal deputy of the foreign marketing authorization holder. So the de facto license holder could be perceived as the local distributor, but essentially the regulatory approval would be issued in the name of the foreign legal manufacturer with respect to China. And there are actually large distributors like DKSH in Asia Pacific in particular. They are very focused on distribution business only, and they are reputable and reliable. So there are many small medtech companies working with those established distributors in Asia Pacific, leveraging their network without setting up legal entities, and also not worrying too much of the risk of not being able to take their licenses back. Of course, there are more local distributors in different countries where those local distributors may not always align their business interests with the foreign marketing authorization holders or the foreign legal manufacturer. So in that respect, contractually, we always would try to enforce, I think, the right to ask the distributor to reverse the marketing authorization holder designation to the foreign legal manufacturer or its designated legal entity in that market if the distribution agreement terminates. But depending on each market, the possibility of enforcing the obligation, especially if the distributor refuses to cooperate, whether the local court allows special performance, which means you don't necessarily need the local distributor to cooperate. You just go to the court, get a favorable decision, and change the registration with the regulatory authorities. That also will change how likely you can easily take your licenses back. So there are a lot of risks and I would say considerations that companies will have to pay attention to, but those are not barriers or hurdles that you cannot overcome. I would say that's most likely a business decision depending on the potential of the markets.
Very helpful, Catherine. Thanks for that. I want to talk a little bit about the entity type and structure, and maybe I'll turn to Alison first on this. What are some of the typical legal entities that you recommend your healthcare clients, and what are some of the entities that sort of best balance liability, general protection, capital efficiency at an early stage? And one of the things I wanted to pick up on was what you spoke earlier about as one of the key considerations is about employment. And what are some of the best legal structures to make sure that you can start to build a small team locally in some of the jurisdictions here?
Thank you. The key issue to really consider is that there's lots of different structures that you can have. You can of course set up entities under your own as subsidiaries. For example, it's quite easy to set up in Singapore and Hong Kong. Off-the-shelf companies are pretty easy to get. In other countries, it's much more difficult because you may have to appoint a local partner to be one of the shareholders, directors, etc. For example, in Thailand, etc. One of the sort of issues when you mentioned in relation to employment is that if you want to set up your own employment and hire people within your own entities, of course, sort of establishing subsidiaries, then you can have direct sort of the employer-employee relationship. And this is really critical because if you are hiring R&D people to develop technology under your entity and you want to be the owner of such sort of IP, etc., then it's critical to make sure that you have the relevant sort of agreements in place. Of course, you can do it in another way. You can have consultancy arrangements with, let's say, external R&D companies, but you need to make sure that the IP gets assigned back to you, so you are the owner. But in relation to sort of having your own employees to create your own technology, this is a very big driver for investors to come in later, because they do like to have your own technology developed in-house. I keep coming back to Hong Kong because I think it's very interesting jurisdiction. The Hong Kong government is really pushing R&D in Hong Kong. So what they've established very much so, and we've been advising quite a number of clients, startups, etc., is the Oasis organization, which sits under Invest Hong Kong. They've earmarked about 30 billion Hong Kong dollars to support companies setting up R&D in Hong Kong. And one of the key sectors are life sciences and healthcare. And within this, you can get government funding and backing to, and a lot of the companies are in Hong Kong Science and Technology Park. And they've set up a lot of R&D there. And many of them have used Hong Kong, as Justina mentioned, is a place for fundraising, whether from the government or from private companies. And they've set up in Hong Kong Science Park, which is a great ecosystem with a bunch of startups and mid-size and even companies that have actually gone to IPO. And they've employed R&D people within that sort of vehicle of a local subsidiary, etc. So I think what's very important is that the ease of doing business is one of the drivers as to whether you decide to set up or extend overseas in your business, because it's the ease of doing business. How easy is it to get a company set up? What's the ecosystem like? What's the fundraising environment? And then how to expand and hopefully become a unicorn and go IPO.
Yeah, no, that's very helpful. And so what I'm hearing is Hong Kong, Singapore really are the two jurisdictions where it's really easy, straightforward. This can be done, and I've done it myself in Singapore multiple times. It can be done within hours. Justina, in terms of entity types and entity structures, value your thoughts on this as well. We use the term branch office very often. A rep office is something that's sort of commonly used, especially in China. What exactly is that? And if you have a rep office, what can you and can you not do, for example, in China?
Thank you for bringing this up, and back to China. But before that, I would share that if you are focusing on APAC, advisable to set up Singapore. Yes, of course, I would like to introduce more of Hong Kong. But if you are going to do business in Thailand, Indonesia, India, other Southeast Asia countries, lots of concerns as to legal environment there and whether you can get your money back after the investment. So generally, I would advise startup to set up Singapore headquarters. I work with our Singapore office closely and visit them from time to time. And I guess over the years, there is certain mechanism set up in Singapore and then investing Southeast Asia country or APAC countries from tax to foreign exchange to the risk that you're going to face in other countries. So there are kind of set of mechanism that help you, including the bank from Singapore, will help you to make sure that your investment is safe. Even there might be some extreme measures of a certain country going to take against companies, and also a supplement as to where you set up your company need to consider tech export control. Because in tech sector, it's always key issue is like where your technology is, whether you can use certain technology overseas, including license, distribution, or you set up your company, and you may fall under the restriction as to technology export control. Or you need to consider when you set up R&D center in certain jurisdiction, whether you can get technology back. That's some issues I would like to supplement. And talking about rep office in China, basically you cannot do any business in the name of a rep office. So for foreign company entering into China in Medicare sector that I used to work with, they generally set up rep office when they are not sure whether they need to enter into this market. So it's more like a liaison office to work with their distributor, local partner, and to help them to set up clinical trial and go next step. And once the market is ready and you're ready, definitely set up subsidiary, because you can do business as a legal entity in this jurisdiction instead of very limited activities you can conduct. That's my observation and thought. Thank you.
No, that's a good point. So a rep office in China could employ, you could employ people at a rep office, but you can't actually do business transactions. Is that right?
Right. You cannot do business transaction in the name of rep office. So it's just a liaison office that you keep in touch with the industry, and you can do very limited activities, but now then it's like business essential. So it's just like test water or touching point that you enter into certain market. If you want to do business as a legal entity in China, you need to set up subsidiary, usually only owned foreign entity or joint venture. If you have a local partner, that's the entity type you're going to choose. And obviously, it's the same in other jurisdictions. And if you just really want to do business there, you might need to set up subsidiary instead of choosing other forms of office. That's those kind of temporary or transitional instead of just you can do business in such kind of entity's name.
Yeah, no, that's helpful. Thank you. Catherine, we spoke earlier about doing a Cayman Island type structure.
Yeah.
And maybe do you want to share some of your thoughts around that? Because you've advised a lot of medtech companies here in the region, and that's an option that it seems they favor. And
Yes.
why would a company want that, and how would you structure it?
So the Cayman structure actually is popular for some time because of the ease of deciding on the shareholder agreement level, what's the rights and responsibilities of different investors. And it's mostly considered when the medtech company is trying to do fundraising. And if they wanted to actually separate the operation from the actual domicile of the business, they could consider different layers of the corporate structure. So they may have operations in one particular country, say China, and for tax reasons, they wanted to set up an intermediary holding company so the investor can decide to put money at the intermediary level instead of on the China operating company level. And eventually they have a Cayman company that could potentially work for the fundraising purposes, could also work for eventual public listing purposes. There are different considerations, but generally speaking, the Cayman structure is very well known by investors around the globe. So having an ultimate holding company in Cayman Island is probably most likely to align with your potential investors. I don't think you have to consider Cayman structure at a later stage of the company operation. Typically, companies start with the incorporation because most of the management team, the technology, and the product development is in one country. And over time, when you are going to consider fundraising, and then maybe the next phase is you're going to consider listing the company, you would probably think of different layers of the company structure to make it more amenable by the investors.
Right. Yeah, thanks for that. And Justina is nodding, and must be something that you work with some of your clients on as well. Anything maybe you want to add to that?
Definitely. And I suggest most startup adopt this Cayman structure, but nowadays it's like lots of tech company choose simple holding company as well, because it's just easy to access the local investors. And if you are looking at investor in United States, and you may consider Delaware structure. I think the only interesting comments I received for this Cayman structure is from our European office, and they have a concern of from tax issues, the two pillars. And so, yes, of course, Cayman structure is the most easy, straightforward, most efficient holding structure if you're looking for fundraising and IPO in major jurisdictions. But be flexible. As I share, is like where the money is, where your investors are. They may prefer Singapore structure or local European structure or Australian structure or US structure. But overall, Delaware, Cayman structure is like works for most jurisdiction. But it's interesting observation is like basically your angel investor shape the holding structure for you, because they choose for you. They might just familiar with Cayman style fundraising documents, which is quite different from Hong Kong, Singapore, or US. And then they just persuade the startup set up Cayman structure. That's good. But there are investors kind of share with me, it's like, Justina, we don't like a Cayman structure. Can we just have a Singapore structure and can invest in this, and we can do restructuring if this company do very well and in the future, and let's see. And in that case, I guess just follow the investors in structure, because they have the money, they are calling or set up this structure. Nothing wrong, as Catherine shared, is like you can do many layers of company during the whole time, during the life cycle of your startup journey. And there are many choices. It's not like you have to do fundraising as a holding company layer, and you can do, if you have a Cayman and a Singapore structure, you can choose, let's say investor choose to which layer they are going to invest in. So there are a lot of flexibility in this as well.
Got it. Thanks for that. That's very helpful. Just a quick reminder to our companies, founders, CEOs on the webinar. Do feel free to queue up your questions. I think we have some already. Just use the Q&A function at the bottom of your screen. I think that's generally preferred to the chat, or you can use either. and then we'll get to your questions a little bit later on. I want to take a step back for a moment and maybe turn to Alison here on given the number of life science companies that you work with across a number of with a broad range of talent challenges, potentially IP, regulatory, employment, and so on. What are some of the pitfalls that you see startups perhaps stumble into that where you have to come in and sort of rescue them from a legal standpoint? And related to that, at what point in the early development of a healthcare startup should they begin, in your view, to make contact with external legal counsel? And what are some of those things that they should bring to their attention to begin with? Typically, it's you, apart from incorporation, it's IP, but I'd value your thoughts on this.
Thank you. I do think that, you know, startups now are so much more sophisticated than years ago. I mean, I think that now they do have, as I said, an ecosystem, and they do have access to really good legal service providers that can help them, or, you know, your organization helps them a lot. But the things that I've really been involved with and to at least assist and startups is really in relation, as I said, mentioned, is IP. Sometimes that they may have locked in their IP initially, but there's improvements or developments that they've sort of, because there's so much things to consider that they may not have then filed for new patent applications, etc., or designs, and they haven't locked it in. Because when we're advising our startup clients, we always say, look, before you go to speak to any investors or, you know, disclosure for sort of government investors, whatever, you must get in at least your patent applications in, so that you've locked it in, and then you can protect you, because once you disclose your invention, then all of those rights are gone. So that is one of the critical things. And I do understand, and we have advised that there sometimes, you know, it's not easy, because patent applications are not cheap. Drafting the specification and making sure the claims, you can avoid the prior art, and you can actually get something that's a patentable invention, is not easy. But there are ways to just at least do a primary filing, and then stagger the cost of getting your patent protection later. So, for example, you can use PCT. You can sort of, if your cash flow issues, you could basically select the jurisdictions that you're interested in, delay it maybe by even 30 months. So there's lots of ways to play on the timing of getting patents and IP rights, you know, registered before you sort of start growing the company. Other things that we've sort of advised our clients on is that at the beginning, when there's a corporate entity being structured and everyone's excited about the business, then there's not really a lot of thought given into sort of making sure the shareholders' agreements are good, the assignment, apportionment of IP, who owns the IP, etc. And then when there is a fallout, you know, years down the line, there is an inability to exit quickly, because the agreements may not have been, you know, drafted in a way that makes the mechanism easy, which means that if you have a dispute, and I have dealt with disputes situation, and the problem is that litigation, whether you're doing it in Hong Kong, Singapore, China, whatever, it takes time, and there's a lot of effort and resources taking in that, and therefore your competitors are already motoring ahead in front of you. So what's key is that it really is important to get your legal advisors and to help you to sort out your key contractual agreements, for example, like I said, shareholders agreements, your IP, employment, etc. Those are critical. And then there are other things which you could operate on a sort of red light, green light, amber light basis, where you could do a snapshot, and there's some elements of commercial risk that a startup will have to take, because, you know, you don't have unlimited resources to spend on legal fees. But in my advice, in my experience helping startups, is that there is some things that are non-negotiable that you will have to spend and have legal spend on, and there's other things that you could decide to have as a nice to have, etc. But things like corporate governance, sort of compliance, whether, you know, for data protection, IP, employment, all of these are critical to make sure that, you know, your business is protected and will have longevity.
That's great guidance there, Alison. Thanks for that. Catherine, I'll essentially ask you the same question. What are some of the pitfalls or the challenges that you see smaller companies that you work with as clients run into, and are they similar to what Alison outlined, or are there things that you come across that are maybe a bit different that they should bear in mind?
I think I definitely concur what the issues Alison had outlined. There could be potential, I would say, considerations for startup companies because they are usually technology based. So how they can actually move to the next level of product development, which is usually much more cost intensive and capital intensive, is a very important key question, because I don't think all the companies I work with wanted to develop the technology for clinical applications in-house. Once they have a prototype that is relatively mature and finalized, that would be the time when they decide either to start fundraising and continue their development program, or they will try to license their technology out to another larger medtech company for clinical development, because I think that's usually a very important decision to make. I also believe that is a good timing to consider what is the split of right that this company wanted to progress over time, because usually you can have the immediate access to your home base. It doesn't necessarily mean you will have to stay in your home base, and that's probably a good question to consider whether you want to enter into different markets and in what fashion.
Yeah, great point, Catherine. Justina, you work with slightly different companies in the tech arena. Any particular challenges that they come across that you'd like to flag here?
One of my expertise, and I'm very proud of, is like when I advise startup, I help founders or to help them in certain aspects as to how to protect themselves, how to make sure that they are fully authorized and they have a sufficient authorization under the shareholders agreement. They are able to do this kind of expansion overseas without triggering much approval mechanism. And also definitely founders need to pay attention to liabilities they may have under the shareholders agreement and share purchase agreement. So that's one aspect, is like once you have fundraising, check with your lawyer and check your documents carefully. Once you enter into certain market, it might trigger directors' approval from the investors or even shareholders' approval. That's one thing. And yes, of course, once after you have a full evaluation from market, from compliance, that you enter into certain market, for example, enter into United States, it's very costly to do business there. And as Alison and Catherine already mentioned, data compliance, employment, tax, whether you have a sufficient insurance match the stage of your startup. That's all the elements you are going to consider before any crisis occur. And over time, help startup and founder manage their relationship with their investors. That's quite important for the journey of any startup to be a successful one. And you need your shareholders support you and share with you their resources to help you. As Alice mentioned, that startup may not have an unlimited legal budget to do everything, and they often expect their legal counsel cover both aspects. But oftentimes it's operational issues, and your shareholders and other startups that may share with you how to do business there is. But practically, for example, if you have a ESOP arrangement in the United States, and you need to follow the laws there. And the easy way is like you have a certain agents to help you to do all this kind of filing tax and find the right advisor, not necessarily the legal advisor that we are on the panel list today that may help start up with company.
Great point. Thanks for that, Justina. I will ask you later about the selection of an advisor or selection of a legal counsel and what a startup should think about in evaluating picking a legal counsel. But I want to just stay with you for a minute, Justina. When we spoke, so we have a number of questions that have come in from our startup companies. Some of them were asked earlier, some were asked now. We'll get to some of those a little bit later on. We've touched on the repatriation of profit, and I just wanted to get your perspective as a corporate lawyer at a high level. Where is this particularly difficult, and what are some of the jurisdictions that startups should just be really careful about, and are there ways, easy ways, obvious ways to work around some of that?
I guess I'm not going to highlight those countries definitely are high risk and check there are all kind of ranking as to the business environment.
Okay.
There are a lot of professional international institutions doing this. So for example, UAE is on the rank as I guess the third or the fourth country welcome foreign investment, and the business environment is good. And my suggestion is, I think the whole journey of startup is quite business driven. Yes, you need to consider the risk whether you invest in a certain country and you can never get your investment back. A good lawyer can help you design structure like have a certain layer of corporate structure in Hong Kong and all those countries that with friendly business environment that you can easily get your investment back. And of course, doing APAC, doing business in APAC, I share with the listeners here previously. If you are investing in certain high-risk countries in Southeast Asia, definitely choose Singapore as your sub headquarters here, and use your Singapore company to invest in those countries, and use the mechanism that the banks in Singapore can offer you to design how your money come into that country, and then they can help you to get your money back in case there is any foreign exchange control. And I guess we highlight enough legal risk, but one thing on top of my mind is like put the geopolitical risk in your mind these days. I guess nobody is prepared for this, but if you are doing business in China and US, pay attention to those data tech export control that each country has input in this tech competition, and also depends on which country you're from, and pay attention to the politics, the international one, and whether your country keep good relationship with certain countries. Definitely something you need to consider after all the parameters that we mentioned, that quite important that you successfully enter into certain markets, but depends on the nationality of the founders and where your company is headquartered. So pay attention to those political tensions that your country, your home country may have with other countries, and the treaties your country with other countries is definitely something startup needs to pay attention to. I guess most tech companies not prepared for this kind of situation, but it's something plays quite important part as we touch base as to tariff and then tech export control And also when you enter into a certain market, definitely lots of reviews from national security or data compliance. Those things seems these days play more important role that whether you can get the license or you can pass the qualify in certain jurisdiction.
Yeah, yeah, good guidance there. Thank you for that. Alison, quick question to you in terms of a startup who currently doesn't have any external counsel appointed. How do they find one? How do they evaluate one? Should they find a dedicated IP lawyer and then work with multiple different legal firms depending on what they're currently working with, or how would you advise they evaluate a potential legal partner?
I think it's really important to find a firm with doesn't have to be a global footprint, but a footprint with many geographical locations. So my other panelists, obviously their firms are excellent and they have geographical spreads, as does Bird & Bird. I think it's very important, and I think you would know not straight away, but once you speak to a number of firms and really assess what their expertise. Do they have expertise on IP, regulatory issues, corporate issues, and do they have ability to get in a team? Because no one lawyer can advise on everything, and whether they work well as a team. And I think it's very important to do your due diligence at the beginning to make sure that you can get the right team in place. I work with my data colleagues, with my employment colleagues to service my life sciences and healthcare clients, etc. And how strong are they in cross-border work? Because it's really very important to make sure that they are able to service you in the countries of your interest, but at the same level and standard and responsiveness as you're used to. So these are the critical sort of questions and to really ask of your law firms. And then, of course, with our clients and many clients, is pricing would be one of the factors to be taken into account. But don't be driven only by that. I think that if you are wanting to become a unicorn, then it's worth paying the money at the outset and continue with a really good law firm that understands and can grow with your business and really understand your business. And a lot of times you can get recommendations from other startups, from the medtech innovators, and there are many law firms, but I do think that there's only so many that really know about sort of the life sciences and healthcare sector.
Great point. Thanks for that. It's almost top of the hour, and obviously we've covered a number of topics that each could have warranted their own 1-hour webinar. So we could have done a 2-day conference on many of these topics. So I wanted to thank our panelists for their insights. Before we wrap up and go into Q&A, I did want to ask each of our panelists to, and I'll start maybe with Catherine, just share any final pieces of advice. You have 30 or so startup medtech founders and CEOs on the webinar here today. What advice would you give them as they run into legal challenges and start to think about expanding into new jurisdictions? Catherine.
I would say, actually, for a startup company, probably the most important compelling question to think about is how you can cement your position in your home market. And then you can consider strategically what are the key priority or the top priority countries you want to cover and in what ways. As I said, the business strategy should always be the guiding principle to determine your next steps. And lastly, I would say it's important, I fully concur with Alison, to seek good counsel's advice, because there are a lot of opportunities, but also pitfalls that companies should be aware of. If you are working with a good counsel, you should save a lot of time and efforts navigating the uncharted water by yourself.
Great points. Thank you for that. Justina, final pieces of advice.
Yeah, for founders and the startup, I totally agree with Alison and Catherine in the sharing that to have a good legal counsel is quite important for your safe journey for this long journey to your successful IPO or merger acquisition. What I can share more is like definitely as a founder and your team shape your product and your business strategy. And investor is definitely the important factor you need to consider to enable you have a sufficient funds to invest in to enter into any market at your choice and to support you. And in addition to legal advisor, find your friends in foreign countries that might be some startup in your industry or successful entrepreneurs in your industry, and what they can share the wisdom is more than just legal advice. I think that part is important for your successful journey as well.
That's a great point, actually, and we are working on ways to help facilitate some of that through MedTech Innovator. Thanks, Justina. And Alison, I'll let you have the last word here. Any final thoughts, pieces of advice to our cohort?
I agree with everything that Justina and Catherine just mentioned. I think what my final thoughts are, just be flexible. I think that it's not easy to be a startup, and I do think that there's a lot of, blood, sweat, and tears. I do think that even if there are issues at the beginning, that doesn't mean that they can't be resolved with good legal counsel. There are always opportunities there. If one country becomes much more difficult to do business, go to another country, but have good counsel that can help you be flexible with your plans, because business plans, excellent, absolutely have to do that, but everyone has to be flexible. And given the geopolitics that we have to live with, then things are going to change. So be flexible. That would be my final advice.
Very good. Well, thank you all three, Alison, Catherine, Justina. Been a great discussion. As I said, we could have gone on well beyond the hour. I really appreciate you sharing your thoughts and insights. Don't hang up. We will just cut our live stream here. So thank you to those of you who followed us on LinkedIn and YouTube. And